Landlords have a lot of power over your home, but not unlimited power. Some things they do might feel normal because everyone just goes along with it, but they're actually illegal. Today we're covering 5 things your landlord legally cannot do, no matter what your lease says. Some of these might surprise you, and by the end, you'll know exactly what to do if any of them happen to you. First, entering your home without proper notice. In most states, landlords are required to give at least 24 to 48 hours notice before entering your unit, except in genuine emergencies. That includes maintenance visits, showings to new tenants, or just checking in. None of that skips the notice requirement. Imagine coming home to find your landlord already inside, with no notice and no emergency. That's a clear violation. If this happens, keep a simple log every time. The date, the time, and what happened. Then, put it in writing to your landlord directly, referencing your state's notice requirement. This creates a paper trail if it keeps happening. If it continues, your local housing authority or a tenant rights organization can help you take it further. Next, shutting off your utilities or changing your locks to force you out. This is called a self-help eviction, and it's illegal in nearly every state, regardless of how far behind on rent you are. The only legal way to remove a tenant is through the court system, never by cutting off water, power, or changing the locks. Picture coming home from work to find your key doesn't work anymore, with no court order, no warning, nothing. If this happens, document it immediately with photos, and contact a tenant rights organization or your local non-emergency police line the same day. Then there's refusing to make necessary repairs. Every state has some version of what's called the implied warranty of habitability, meaning your home has to meet basic living standards no matter what your lease says. That includes working plumbing, heat, hot water, no dangerous mold or pest infestations, and structurally safe conditions. Picture reporting no heat in the middle of winter and weeks going by with nothing fixed. Always put repair requests in writing, even if you already asked in person, so there's a clear record. If it's ignored, many states allow specific remedies, repairing it yourself and deducting the cost, withholding rent, or reporting it to a local housing inspector. Be careful here though. These remedies usually require following your state's exact process, or you risk facing your own eviction notice for withheld rent. Keep every request and every response, or lack of response, clearly documented and dated. Here's one people really underestimate: discrimination. Under federal fair housing law, landlords cannot deny housing, treat you differently, or evict you because of race, religion, sex, national origin, familial status, or disability. Many states and cities add even more protected categories, like sexual orientation, source of income, or age. This includes subtle stuff too. Different rules applied only to certain tenants, refusing reasonable accommodations for a disability, or steering families with kids towards specific units. If you suspect discrimination, document everything specifically: dates, what was said, and how it differed from how others were treated. Then consider filing a complaint with the Department of Housing and Urban Development. It's free, and it's specifically built to handle exactly this. And the last one, keeping your security deposit without a valid, itemized reason. Most states require landlords to return your deposit within a specific window after you move out, often 14 to 30 days depending on where you live. They're also generally required to provide an itemized list of any deductions, not just keep the money and go silent. Normal wear and tear, faded paint, minor carpet wear, small nail holes, generally cannot be deducted from your deposit. Picture moving out, and weeks later your deposit never shows up, with no explanation at all. Send a written demand citing your state's deposit law and deadline. Often this alone is enough to get it resolved. If it's still unresolved, small claims court is specifically built to handle exactly this kind of case. A few more quick ones worth knowing. They generally can't raise your rent in violation of your lease terms or local rent control laws. They can't retaliate against you, like suddenly raising rent or issuing a notice, right after you file a complaint or request a repair. And they can't include illegal clauses in your lease, like waiving your right to sue them, even if you signed it. Let's cover a couple quick follow-up questions. What if my lease says my landlord can do one of these things? A lease can't legally override these protections. An illegal clause is generally unenforceable even if you signed it. What if I'm not sure whether what happened is actually illegal? Local tenant rights organizations usually offer free consultations specifically to answer exactly this. What if I already got an eviction notice after complaining about one of these? That timing itself can be a legal defense. Check out our video on fighting an eviction notice for the full breakdown. So here's the recap. Your landlord can't enter without notice, can't force you out themselves, can't ignore necessary repairs, can't discriminate against you, and can't keep your deposit without a valid reason. None of these are optional courtesies. They're legal protections that exist whether or not your landlord tells you about them. This video is general education, not legal advice. Landlord-tenant laws vary significantly by state and city, so confirm specifics with your local tenant rights resources or a licensed attorney. If this helped, check out how to fight an eviction notice and how to win in small claims court, both linked right here. See you in the next one.